library too. So good afternoon, everyone. I'm delighted to be with you this afternoon to discuss estate planning. My name is Kendra Bowen. I'm a staff attorney at the Housing and Economic Rights Advocates, and I'm joined today with Christine Nieves. She's one of the law clerks that we have at HERA as well. So once again, delighted to present to you today, and we're going to discuss everything related to estate planning. Please keep in mind that you may have questions as we roll along together this afternoon. However, if you will hold your questions until the end of the presentation, I will really try to answer everyone's question. I would highly encourage people not to share personal information, just to kind of couch it in a general manner, okay? All right, so we will go ahead and get started. We're going to discuss estate planning. These are the basics of estate planning. The estate planning foundation that most of us need who are over the age of 18. Next slide. We're going to discuss the what, who, when, why, and where estate planning. However, first, let's discuss a couple of myths, a couple barriers that sometimes prevent people from doing their estate planning. Next slide. So some folks think, hey, I don't own a house. I don't anticipate owning a house here in California. I don't need estate planning. Well, hopefully you'll discover that that is false, because even if you don't anticipate owning a major asset here in California, you have yourself, you have your finances, you have your health, and you will find that some estate planning documents will govern and affect the latter stages in life, and making sure that you have people in place to handle those in a manner that you would desire and that you wish. Next slide, please. Another barrier to estate planning is some people realize that, yes, California does have a mechanism in place to distribute your assets at your passing. It's called intestate succession. So if you're a single parent and you have, let's say, 3 kids, I don't need to do estate planning because one day my assets will go to my 3 kids. Well, for many people who have homes in California, while your assets, your home would go to your 3 kids, it will probably do so through what we call the probate proceeding. We're going to discuss that in a bit. And it's an expensive, arduous process. Plus, if you rather have something different take place, for whatever your reason, you want your assets to only go to 2 of your children, you can definitely make that happen. However, you must have the proper estate planning documents in place to make sure that does take place when you pass away. Next slide, please. Some folks feel that, hey, they were going on a trip, they created a will, therefore all of their estate planning is finished and their family won't need to go through probate. I don't need anything other than a will. Well, I think you'll discover, hopefully by the end of our presentation, that a will typically is not enough. If you're a homeowner and you have a will, your assets will go through the probate process and it will potentially cost your family a lot of time and money. So having a will is typically not enough. We're going to discuss the ins and outs of other documents that most of us need. And next slide, please. And then the last myth is, I hear this all the time, my family is close. We all understand what we eventually want to take place one day with my health and my assets when I pass away. We don't need to worry about anything. Well, most of us have heard of instances where an otherwise close family becomes very disjointed and sometimes acts in a poor way towards each other when a parent passes away. They're in a vulnerable state, those family members. Spouses will sometimes become involved, and we really see the worst comes out and those little horns come up out of people. So once again, if you take the time to please prepare your estate planning documents now before they're needed, you will help maintain that family peace. Next slide, please. So estate planning in a nutshell is a process, and it involves not only your property when you pass away, but the people in your life. You prepare the documents now to address future needs. Next slide, please. We prepare estate planning documents to address incapacity later. So incapacity is a stage, perhaps like Alzheimer's, dementia, a stage when we do not know how to take care of our financial affairs or our personal and healthcare affairs. So there are documents we prepare now to plan for incapacity. And then the second group of documents and issues is post-death planning. When I pass away, who will be in charge of my minor children or any dependent adults? Who will manage the distribution of the assets I have at that time? And where are my assets going to go? So those are the two groups of estate planning topics that we will discuss, and we have certain documents that apply to each set of issues. Next slide, please. The documents on the left in blue are the documents that are really, frankly, mostly important when we are alive. So a durable power of attorney for financial purposes and a healthcare directive are documents that we can prepare to make sure that those latter stages of life, let's say we have Alzheimer's or dementia one day, go according to our terms as opposed to someone else's terms. We want someone that we wholeheartedly trust to govern what happens to our finances if we're not able to take care of our financial affairs, and to direct our health care, once again, if we are unable to make good healthcare decisions for ourselves. And then the documents in yellow really govern the distribution of our assets once we pass away. Yes, a will can distribute assets as long as it's under the probate threshold, which we will discuss shortly. And then if we did create a trust when we were alive, when we pass away, no one can change that trust, and that trust will once again distribute assets at our passing. All right, so first we're going to dive into the group of estate planning documents that's a little bit bigger and sometimes more significant to folks. What happens when we pass away one day? So one goal we should have as California residents is to avoid probate. Probate is a legal process that frankly costs quite a bit of money, and it typically takes at least a year and a day. So the probate threshold that we have here in California is the amount of $208,850. If you have assets that are worth more than that amount, and you have not utilized a mechanism to distribute those at your passing, your family could need to go through the probate process we have here. And we don't want to put that on your family members. We want to save money and make sure that more money goes into the pockets of your loved ones, as opposed to attorneys having to lead your family through the probate process. The good news is there are various tools we can utilize to avoid probate. Next slide, please. Here are the tools we have. So on the upper tier of yellow bubbles we have here on the far left, you can create a revocable trust. That trust is you. You still own all your assets in that trust. And then once you create that trust, you can place your assets into the trust. At your passing, when you pass away, the assets in the trust avoid probate typically and will be distributed to your people named in the trust, called beneficiaries, without your family, your estate, having to go through the probate process. Another tool that we have on the upper row, on the upper row, second in from the left, is to create a transfer on death deed. This is relevant for real property owners in California, and it's essentially a several-page deed. We'll look at an example shortly, where you can indicate the people you would want to inherit your home when you pass away. Okay, so again, this is only relevant for real property owners of a home, townhome, or condo, and you can actually put beneficiaries on a deed, file it properly, and then once again, when you pass away, your house will likely go to those people. On the upper row, second in from the right, we have multiple party accounts, or POD accounts, which is a pay on death account. On any financial account, a bank account, credit union account, if you happen to have some kind of investment account, typically you can meet with a personal banker and indicate, once again, a beneficiary on that account, a pay on death beneficiary on that account. When you pass away one day, that account will likely go to the beneficiaries you have taken the time to name on that account. And then on the upper row, the bubble to the far right, we can just have assets that are less than $208,850, and it's most likely the case that our family will not need to go through the probate process if that's the case. On the bottom row, if you look at that middle bubble and the bubble to the far left, we can hold assets with someone either as a joint tenant or with a spouse as a as a part of a community property type of holding, and that will only avoid probate as to the first death. Okay, so let's say I have a married couple and they own their property as community property with right of survivorship. Should one of those members pass away, there will likely not be a probate with that particular piece of property when it goes to the surviving spouse of that couple. However, the last person standing needs to actively do something to avoid probate. So owning property with a spouse or with a joint tenant only avoids probate as to the first death. It does not avoid probate when that second person passes away. And then on the lower row to the far right, we have placing beneficiaries, designating beneficiaries on either retirement accounts or life insurance policies. Once again, with that particular asset, when you pass away, if you have living beneficiaries on that asset, when you pass away, that asset will once again avoid probate and most likely go to those people. So we don't expect you to know how to utilize each of these tools for every asset you have. You can typically speak to a professional, an estate planning person, or the company that holds your retirement account, and they should be able to guide you as to how to avoid probate with those particular assets. So let's look a little bit more closely at that revocable living trust. Next slide, please. So the trust might seem like something that only wealthy people need to utilize, and that is not the case. Remember, we want to avoid throwing our estate into probate by owning assets that exceed $208,850, and we want to utilize the tools in those yellow bubbles we just looked at. One of them is creating a trust. So if you create a trust with a lawyer or law firm, you completely own the assets that you are going to place in that trust. You are the only person, and when I mean you, I do mean you, both people in a married couple as you. You are the only people who can change your decisions in the trust. You can utilize all those assets in your trust. You can spend everything and not be accountable to the next tier of people who would potentially inherit. There are no limitations with what you can do with your assets in your own trust. It's completely revocable, amendable. So please keep that in mind. The trust will state guardians of any minor children or dependent adults. It will also state the beneficiaries, the people that you want to one day inherit your assets when you pass away. And then the other main thing a trust will do is it will allow you to nominate the person who is in charge of that process of distributing your assets when you one day pass away. Keep in mind that when you make these decisions for your trust, they are not set in stone until the moment that you pass away. Rather, you can change your decisions at any point as long as you have your mental faculties, okay? Trusts may be called all kinds of different things. They can be called a declaration of trust, a trust agreement, an inter vivos trust, a living trust. Really doesn't matter what it's called. The main point it is you control your trust, and you can change anything you have reflected in those terms of the trust. In trust, you will typically identify all of your family members. So if you have 4 children and for whatever your reason is, you don't even need to share that with an attorney. You want everything to one day go to 3 of your kids. You will identify the fact that you realize you have 4 children, but you can state that you want your assets to be split among your 3 kids that you have chosen to inherit them. That is absolutely fine. Different provisions in trusts will once again kind of help keep the family peace. For instance, in our trusts, and frankly, even in our wills for people who are not homeowners, we have a no contest clause. And what this is it states that if any of your beneficiaries say, gosh, mom promised me 90% of the estate and my 2 other siblings have to split the other 10%, if that beneficiary really tries to push that and you have stated otherwise in your trust, that beneficiary won't get anything. So it really, having certain clauses in that trust makes it easy for your next tier of people to inherit what they need and minimizing attorney fees. Next slide, please. Let's look at the difference in the process from someone who passed away. Let's say they owned a home worth $1 million. And when we do state the value of your estate, we don't mean the value of your estate subject to a mortgage, but because the probate court does not really does not consider that when evaluating what your estate is worth. We look at your estate amount as being gross. So let's say someone has a home worth $1 million and has a loan against it of, $300,000 or $800,000. So while the net there, the equity in your home might be much less than $1 million, the probate court does not consider that when they evaluate the gross value of an estate. So let's go back to this example of someone owning a townhome worth $1 million. They might have a loan against it of $800,000, but we're going to look at the difference in the process, what takes place when they eventually pass away. So on the left-hand side, we have the process and the benefits of having a living trust when someone passes away and owns that home worth $1 million. No probate is needed, which saves money and time. The trust is a private record. Typically, the trust will not be filed at the probate court. Once again, your decisions about where your estate would go and who are the guardians of your minor kids, that would be held privately. There are no statutorily guaranteed fees to the successor trustee and their attorney. This saves your family and loved ones money. The successor trustee navigates that process in a streamlined manner and does all of those tasks without court supervision or approval. Many times they don't even need to hire an attorney. The assets in a living trust are not subject to estate recovery, which means if there was a medical claim after death, as long as there was no fraud, the assets in that trust would be protected because they are not subject to probate. And the process just takes a shorter period of time and costs your beneficiaries much less money to administer a living trust that was properly funded. Let's compare that with the other side. Someone who has a will or no will, and once again has that same home worth $1 million and is possibly subject to their mortgage of $800,000, but they are still going to need to go through the probate process. This is whether or not the person had a will. Wills are subject to probate when they relate to an estate that is worth $1 million. Probate is needed. That will becomes public. And if there was no will, the whole probate proceeding is public. Someone can look up the record and find out where your assets are going. There is statutory compensation to the attorney taking the personal representative through probate, and then the personal representative who is appointed by the court also receives a fee, and we will look at those fees shortly. The executor of a will or the personal representative appointed by the court conducts all these tasks under court approval. That's why there are various fees involved. The assets are subject to estate recovery. So, for instance, Medi-Cal could make a claim about these assets subject to probate, and the process takes a long period of time, and it's impersonal, and it costs quite a bit of money. So we much rather have people go through the process on the left as opposed to the process on the right. Next slide, please. For those who don't anticipate owning a home and whose assets are less than $208,850, a will can indicate where you want the contents to your apartment to go, where you would want your car to go, and a little bit of money in a bank account. However, if you're fine with creating a will now, please keep in mind that if your financial situation ever changes and you end up over that amount, that $208,850 amount, probate could be needed, and you want to discuss that with an attorney to make sure that you are doing everything possible to avoid probate. Next slide, please. Probate is the court-supervised process for transferring a deceased person's assets and estate to the beneficiaries named in the will. The court validates the will, appoints a personal representative, and there are various stages to the probate process, and we're going to look at those, and it'll be clear why probate costs a bit of money. Next slide, please. If you do not take the time to indicate where you want your assets to go now and who is going to be in charge of that distribution of our assets when you pass away, the state of California will make all those decisions for you. So typically, they will appoint and distribute your assets to a surviving spouse or domestic partner, to all of your kids equally. If you have no kids, to your grandchildren. If you have no kids or grandchildren, to your parents, and then to your siblings. So if this is not what you would want to have take place, please take the time now to indicate what you would want to have happen in your properly executed estate planning documents. Next slide, please. This once again illustrates the fact that the state of California will one day find someone to give your assets to. However, this may not be what you would want, so we much rather have your intentions take place one day rather than the state's. This is a diagram of just some of the steps needed to go through the probate process. And this probate process is needed if people didn't actively utilize the tools in those yellow bubbles at the outset of this presentation. So one of the first steps of going through probate is the personal representative, along with their attorney, will file a petition for probate. They will publish a notice of that petition. They'll mail notices to certain people and file a bond. They will obtain a hearing date on the petition for probate. They will have to prepare an inventory and appraisal and send all of that to the probate referee and have that filed with the court. They will prepare notices, pay debts, file tax returns, file an accounting and a final distribution with the court, mail notices to interested people, obtain a hearing date, and the judge will sign off on a final distribution. And then they will distribute assets, and then they will have to file a declaration for final discharge in the court. So as you see, there is reason for a personal representative to have to hire legal counsel just to run an estate through probate. It's a very protracted process, and if they just had a trust, they could avoid all of these steps and keep the process relatively private within their families. Next slide, please. Let's look at those statutory probate fees here. So think of our person, the owner of a condo or townhome, who owns that townhome, which is worth $1 million. And they have a loan against it of $800,000. Okay, so there's $200,000 of equity in their home. But if we go to the 6th row down, we will see across the page that in order to probate that equity, that $200,000 there, the minimal fee that will be paid to an attorney handling that probate is $23,000. However, there's another $23,000 that will be distributed to the personal representative of that estate. So a minimum of $46,000 will be distributed, and that is one of the first fees paid. Once again, we much rather have this amount in the pockets of your loved ones, and so we want to avoid these fees. These fees, frankly, don't even take into account the probate referee fees and anything the attorney considers extraordinary. Next slide, please. Okay, we're going to look at a little example here. So we have a person who passed away, once again, owning that condo worth $1 million. They pass away. On the left, we have an illustration of what happens if they had a trust and they passed away, and there is a trust administration that needs to take place to distribute that asset. So with that $1 million, we subtract their loan against that property of $300,000, and so we have a net value of $700,000. Let's say the successor trustee and the kids decide, we need to sell the home. So we have to stage it, have it repainted. There's $20,000 worth of costs there that is paid from the estate. After we subtract that $20,000, we have a balance, after all of this is done, of $680,000 that can be distributed to the beneficiaries of that trust. Let's compare that to the person who passed away owning that same $1 million condo with a loan of $300,000, but did not have a trust and did not have a transfer on death deed. They had merely a will, or they didn't have a will, but the process is the same regardless. So while they had that same $1 million home subject to that $300,000 loan, leaving a net value of $700,000 there, and let's say they once again decided they needed to sell the home, so they had to have it painted and such, that reduced that balance to that same $680,000 figure. In this case, because the estate is subject to probate, $23,000 comes off the top, one of the first fees paid to the personal representative, and an additional $23,000 is paid to the attorney hired to run through probate. So we have a much lower balance that is distributed to loved ones. $46,000 less is distributed, and our balance is $634,000. Big difference here. All right, next slide, please. Another example, so we have Pamela who passed away, and I'm going to quiz all of you on this, so please pay attention. Pamela passed away and her deed stated that she owned her home as Pamela, trustee of the Pamela Trust. She had two retirement accounts that she named her friend or sibling, Ben, as a beneficiary. Ben was still alive when Pamela passed. Pamela also had a life insurance policy and she named her mother, Stella, as a first name beneficiary there. She also took the step to name a younger beneficiary on her life insurance policy, and so she named her brother Leo as a secondary beneficiary. Pamela's mother passed away before Pamela. And then Pamela also had a bank account, savings and checking account, and indicated that her boyfriend Tommy was the beneficiary there. So do we think that Pamela's estate needed to go through? And you can put your answers in the chat if you feel like you'd like to do so. Any takers? Okay, next slide. Pamela did everything correctly. There is no probate needed here. Her home is clearly in her trust. Her retirement accounts and life insurance policy had living beneficiaries on them when Pamela passed. Even her bank and checking and savings account had a living beneficiary. So her entire estate, which was over $1 million, went to beneficiaries as named in her either beneficiary documents or her trust. All right, so let's look at the next slide, which is Alex. Alex, once again, had a home worth, you can go to the next one, $1,000, and his deed stated that he owned it as an unmarried man. He had two retirement accounts like Pamela, but he forgot to put beneficiaries on them. He also had a life insurance policy, but he regrettably named an older beneficiary and never took the time to name a second beneficiary, and his father passed before Alex did. And then on Alex's checking and savings account, he put my girlfriend, a very ambiguous designation, as a beneficiary on his bank accounts. Do we think that Alex's estate needed to go through the probate proceeding? You could jump back, I think, one slide, Christy. Great. You guys are correct. Glad there are lots of yeses. Alex didn't do anything correctly. He owns his home himself, not in a trust. He doesn't have any living beneficiaries on his bank accounts, life insurance policies, or retirement accounts. So regrettably, around $50,000 will need to go to the attorney and the personal representative hired to take all of these assets through probate. Let's not be Alex. All right, next slide, please. So we've discussed the tool of having a home and placing it into revocable living trust. We're going to look a little more closely at another tool we have at our disposal here in California of how to avoid probate when you're a real property owner. So you own a townhome or condo or single family unit. It's called the transfer on death deed. So there are a couple limitations here. If you do have agricultural real estate consisting of more than 40 acres, you couldn't use this tool. If you had a sixplex as opposed to a fourplex, you couldn't use this tool. But short of that, this can be used for most types of real estate. It's a 2 to 3 page deed where you indicate beneficiaries by name and you file it at the recorder's office once you sign it with a notary. And we can look at an example here. And believe it or not, if you do this properly, you sign it with a notary, you record it within 60 days of notarization. When you pass away, your real property, this piece of property will likely go to your beneficiaries as stated on this document. A couple of caveats here, and you can go to the next slide, Christy. A couple of caveats are if you change your mind with respect to these beneficiaries, yes, you need to actively revoke it. And then once it's revoked, you have to think, aha, I remember HERA stated I need to actively do something to avoid probate, which means create another transfer on death deed or create a revocable living trust and put the home in the trust. So in any event, this can be a good tool, especially for someone who wants to do something rather quickly. Let's say they have upcoming surgery, they're leaving the country, and they just want to make sure to have peace of mind. Should anything happen, there is a mechanism to avoid probate. So once again, this only works for real property here in California. Next slide, please. Okay, so we have touched upon various subjects and various tools we have to avoid probate with respect to our assets when we pass away. But equally important in my eyes, let's look at the documents we can create now while we're feeling good to govern what happens if we are ever incapacitated. So we're going to look closely at the durable power of attorney for financial purposes and the advanced healthcare directive. These documents are only effective when we are alive, and as you can see here, they become void when we pass away. Next slide, please. So for both of these documents, you are planning for incapacity down the road. Hopefully you never need them, but they are there if needed. So in these documents, you will indicate people that you trust wholeheartedly to make either financial decisions for you, or at least conduct financial matters for you, such as filing your taxes on time, etc., if you weren't able to do so yourself, and to advocate for you in a healthcare setting, once again, if doctors felt that they couldn't have good conversations with you with respect to your health. It's okay to have different people for these different documents. You can become very granular in these documents. So you can indicate if you are in a coma, how much time you want if doctors state your condition's irreversible. You can state if you have dementia, if you do indeed want artificial hydration and nutrition. You can indicate if you have certain limitations with the type of pain relief you want. You can indicate whether you want to remain in your home if possible, as opposed to going to a senior living facility. You create these documents to avoid a conservatorship court proceeding down the road. And once again, if you create these documents and they are comprehensive, it is likely your family will never need to go before a court and have a conservatorship proceeding. Next slide, please. With respect to the durable power of attorney for financial purposes, in this document, you're going to indicate an agent. And the agent is just someone in your circle whom you wholeheartedly trust to handle your finances if you're unable to do so yourself. You can have it set up in any way you want, but the typical ways are to have it immediate, which means, hey, I'm leaving the country for 3 months. I want to indicate an agent so that if I'm gone, I want someone who can in person handle financial matters for me. Or you can set it up to be a springing power of attorney, which means that the power of attorney document must be accompanied by a letter from 1 or 2 physicians stating that you are unable to take care of your financial affairs. And that letter is what springs the power of attorney into becoming effective, okay? So no one would have any power to do anything under this document unless your doctor and perhaps a second doctor indicated that you are unable to handle your finances. There could be a limited authority or a general authority, and you are the one who decides what is appropriate for you in your circumstance and your circle of trusted individuals. Next slide, please. And then for both the durable power of attorney and your advanced healthcare directive, and sometimes that's called a power of attorney for healthcare matters, you would indicate a number 1 agent and then a second agent if the first one wasn't available, and you can indicate a third agent if you would like. You should typically name someone who is assertive, who can stand up to medical professionals and make sure that they are advocating for your best interests. It's best to have people chosen in a consecutive manner rather than having co-agents. Proximity, so geographic proximity can be important with respect to your healthcare directive. If you think about it, if you are in the hospital, you might want your agent to come and size things up with you and your physicians in person to make good decisions for you. With respect to the financial documents, geographic proximity is not such an issue. Of course, these people have to be adults. It's a good idea to periodically review these documents to make sure you still like your choices. If you've had a life-changing event, such as a marriage, divorce, something like that, please look at your documents and make sure that they reflect your current choices. If they don't, the beauty is any of these documents can be changed whenever you would like, but you have to execute a new document with proper legal formalities. And if possible, it's great if you can have an ongoing discussion about your choices with your family and loved ones. So for instance, in a healthcare directive, if you're in a later stage of life and if you have surgery or if you have dementia and you want to make it clear to your loved ones that if something heads south with respect to your medical care, you don't want a lot of heroic things done for you. We can state that in a healthcare directive, but I think it helps when your family hears that from you as well. Next slide, please. We create all of these documents to avoid that conservatorship proceeding. So that's a proceeding where when someone is rendered incapacitated, their family is notified, and all those family members have an opportunity to come to court with their hired attorney and argue in front of the judge about why they think they are the best person to handle your financial affairs for you, and why they think they are the best person to handle your healthcare and personal affairs for you. The judge will try to do the best they can in a 2-hour hearing. However, we much rather have all of you choose for yourselves who would be the best choice. You know your circle the best. You have had years and decades to size people up. So once again, if you make your decisions in properly executed documents, your choices will prevail down the road when it's time to invoke the responsibilities of those people that you've indicated. Next slide, please. The post is an additional document so it's a physician orders for life-sustaining treatment. It is typically a brightly colored document, typically bright blue, and it's meant to garner the attention of medical professionals. So if you're home and something awful happens and you're in very bad shape, if that document is present, medical professionals are supposed to follow that and not do anything heroic to you. Typically, you complete that document with your physician. It's typically a document that older people would complete. Also, a DNR, a do not resuscitate form, can be completed with your physician. And it once again states, let's say that if you're having surgery and you need to be resuscitated, let's say the quality of your life is rather poor anyways, you do not want to be resuscitated. These two documents are not a healthcare directive. They are ancillary, additive to a well-drafted healthcare directive, okay? So you can always add this onto your healthcare directive. Please make sure your healthcare directive is consistent. But if you have these documents, also create a healthcare directive because there are many medical conditions that these documents do not address. Next slide, please. This is what a POLS looks like. It's typically completed with a physician. And then this is what a DNR looks like. If you complete one of these and then change your mind, that is okay. Just let your physician know and remove this from your file. All of these documents are amendable and changeable. Keep in mind with the healthcare directives, if any of you are with Kaiser, Subtle, any of the big institutions we have around here, on their portals, they have a healthcare directive that you can complete. Frankly, when you go in for your next medical appointment, you can ask for a blank healthcare directive, and you can complete that healthcare directive. It typically needs to be witnessed by 2 disinterested people or notarized, and then turn that in the next time you go to your healthcare directive, or sorry, your healthcare practitioner, or upload it to your portal, and that is absolutely fine. That is the one thing that you can DIY, do it yourself. And once again, as long as you're complete in that document and pick people that you wholeheartedly trust, that will be a sufficient healthcare directive, most likely. So once again, the documents in blue are documents that are typically becoming effective while you are living, yet perhaps incapacitated. And those would include mostly your durable power of attorney for financial purposes and an advanced healthcare directive. And then we have the documents in yellow, which will govern the distribution of assets when you pass away. That trust, which you could always change when you were alive, it was revocable while you were alive. The moment you pass away, it's irrevocable. You're not here anymore, so no one else can change it. Your trustee of that trust just has to do what you have taken the time to say in that trust. That's what makes it irrevocable. And then your will, if you had assets under that threshold amount of $208,850, that will could distribute assets as well. Also, keep in mind that the trust and will also nominate guardians for minor children and dependent adults. So those are important documents to have. The blue documents are important to have. So it's best if you're going to take the time to do estate planning, try to do all of this at once while you're in that mindset of completing this. Keeping in mind that you can change any of these whenever you would like, as long as you're still here and you're doing okay. All of this is revocable and amendable and replaced and can be replaced by newer updated documents. Next slide, please. So if any of you proceed with an estate planning attorney or law firm, what you can expect is you'll have an initial meeting, perhaps on the phone. If you are a married couple, it will likely be with your spouse. It's important that both of you are on board with getting your estate planning done. Regardless of how that meeting takes place, you're going to share some personal and financial information with that law firm. The things you will not have to share are Social Security numbers of either yourselves or beneficiaries. You will also not need to share financial information other than ballpark figures of what you have. So you will not need to share where your specific accounts are or any account numbers, okay? The law firm will typically send you a workbook, which you will complete. It's going to ask your legal names, the names of any fiduciaries, the names of your trustees, and the agent for your power of attorney, the agent for your healthcare directive. They do need legal names, no nicknames. And they will use all of that information in order to draft estate planning documents with you. They will end up reviewing those drafts with you. You can make changes, and people sometimes do so. And then eventually you'll get to the point of liking all of your decisions, and you will sign those documents, typically with the notary. And the day that you sign them, they are effective. If you have created a trust, your attorney will also likely have prepared a grant deed where you're taking your property and deeding it to yourself as trustee of your trust. It sounds odd, but that is how you fund your trust. That is the measure that avoids probate one day for your family. Down the road, if you, let's say, purchase your existing home and purchase a new home, you will fund your trust with your new home. And it's very easy to do so. You will let a title company know the name of your trust. They will make sure that last deed is to yourself as trustee of your trust, and your new home will be funded to your trust automatically by your title company. A trust is meant to kind of grow with you as you evolve through life. And then the next thing to remember is to please just review your financial plan periodically. I think sometimes after the first of the year might be a good rule of thumb. Pull out your estate planning documents, make sure you like your decisions, spend 10 minutes on it. Chances are it'll be good for another year. But if it's not, let your estate planning attorney know that you've changed your mind about certain things, and they can amend those documents for you. Next slide, please. These are some examples of folks who did not amend their documents after life-changing events. So for instance, Barry White, he had an estate plan. He had been long time separated from his spouse, but he neglected to change his estate planning documents. So when he passed away, his long-term partner was in litigation with his former wife. They spent many hundreds of thousands of dollars on attorney's fees. Heath Ledger, he created estate planning documents thereafter, had a child. He never amended his estate plan. So once again, regrettably, when he passed away, there was litigation between the old beneficiaries and the representative of his minor child. So update, please, if you will. Also, when we speak of updating, please revisit your beneficiary designation pages on life insurance policies and your retirement accounts, any bank accounts on which you have placed beneficiaries, transfer on death beneficiaries of those accounts. You can change those very easily by contacting those institutions and letting them know you want to change your beneficiaries. You request a change of beneficiary page, and turn that back in. And that will be the newest version of what you want to have happen with that particular asset when you pass away. Next slide, please. This is a little bit about us. We're the Housing and Economic Rights Advocates. We do a lot of work with respect to housing and preserving people's homes. We do foreclosure prevention. We help people with HOA problems. And of course, we have an estate planning department where our fees are on a sliding scale based on last year's income. I find that our fees are typically 25 to 35% of the marketplace out there. So again, we're a law firm, a nonprofit law firm, and we work on all kinds of legal issues to preserve homes for folks. Next slide, please. This is our contact information. So I'll open it up to questions. Ask me any estate planning questions you may have. You can either put them in the chat or we can unmute people if they raise their hand. And once again, I just encourage you to not share any personal information when you phrase your questions. And Christy, okay, let's see here. Thank you. So let's see. And Claire, you can just you can state the question if you would like to for the group, because I'll just end up reading it out for the group so that everyone can learn from the attendee's question. Got it. Okay, understood. So we'll see what comes up here with respect to questions. So with a power of attorney document for financial purposes, I'm assuming you don't need to record it, and we prefer you not record it. It is once again a private document. The reason why we prefer you not record it is if you change your mind and bump off one of the agents you previously chosen for your power of attorney, we prefer there not to be a conflicting power of attorney on record. So it's best to create a power of attorney, sign it with a notary, keep it. You can give it to your agent that you've chosen so that they know that they are on deck to do financial things for you if you were ever incapacitated. But we typically don't want any of that recorded. We don't record a trust either. The only thing that would be recorded is if you are a homeowner and we create a trust and then we prepare a new deed conveying your interest in your home to your own trust, obviously subject to the mortgage, that deed would be recorded. But it just says that you still own your home as trustee of your trust. It doesn't state who it goes to when you pass away. So when people Google an estate plan, this is the question, the Uniform Statutory Will comes up. What's the value of that as a single estate planning document? Well, I guess the value of that would just be, it states if you execute that with following proper legal formalities, which in California is going to involve signing it in front of two disinterested witnesses, it will indicate who your beneficiaries are. And perhaps it will state who the guardians will be that you have chosen for any minor children you have. So it would guide the distribution of your assets that you don't have beneficiaries on when you pass away. The downside is if you're a homeowner, your loved ones, your estate would go through the probate process, and we looked at that in quite a bit of detail. Also, the statutory will does not do anything with respect to incapacity. So if should you become incapacitated, remember a will doesn't really kick in until you pass away. So if you become incapacitated, you don't have a document in place nominating who you choose to handle your financial affairs, nor do you have a document that states who you wholeheartedly trust to govern and to guide your healthcare decisions. So a will has a limited purpose. Someone is asking about storing a will, and I'm assuming other estate planning documents. Who should store it? How many copies should be distributed? So in our practice, we always store, the law firm should store a scan of all of your executed documents. You should be given the originals. You are entitled to your work product at the end of working with a law firm. if you are comfortable giving a copy to your, let's say, successor trustee, that is absolutely fine. If you're comfortable giving it to your children, if they are the beneficiaries in your estate planning documents, that's okay. However, I would not distribute any additional copies at all, because if you think about it, should you change your mind with any of those decisions, there will be older versions floating out there. So once again, we want to help keep that family peace, keep things simple for your folks down the road, and distribute it to a minimal number of people, if at all. The one thing I would like you to distribute, though, is your advanced healthcare directive. So if you have an attorney create a healthcare directive for you, please distribute that to your medical team, to your primary care physician, okay? If you obtain it from, let's say, Kaiser, obviously turn it back into them. But that is one thing that should be distributed. Excuse me. Someone asked if someone does not own a home, can they utilize a transfer on death deed? They cannot, because it has to apply to a particular piece of property. So it's a deed that has a legal description of the property in it in California, so it's only good for homeowners. A good question. Someone asked, if a homeowner has a mortgage on their property, can they still use a transfer on death deed? Absolutely. It doesn't jeopardize the lender's position against the property, so they typically don't care. They will be paid regardless. So most of us have mortgages on our home, so you can absolutely utilize it if you have a mortgage, okay? When someone passes away and there is a mortgage on a piece of property, the mortgage needs to be satisfied in order to convey title to the beneficiaries on it. So in some manner, that lender will need to be satisfied their mortgage amount. However, is there a chance that the beneficiaries could qualify for a mortgage with that same entity? There is. So that'll be a personal decision based on their credit, etc. But the mortgage does not go away when someone passes. And in order to convey good title to that next tier of people, that mortgage will need to be satisfied. And that is one thing that is better about doing a revocable living trust than a transfer on death deed, because if you have other assets subject to or in the trust, when someone passes away, the trust money, let's say an account has $100,000 or something like that, it could be used to satisfy that mortgage, or at least help. These are all very good questions. Keep them coming. We have plenty of time for questions. Good question. Conservators build estate plans. So regrettably, conservators cannot build the estate plans for others in California. No one else can make decisions for you. So that's why we highly encourage people to prepare any of their estate planning documents while they can do so. Because once you've missed that window and you're rendered incapacity, which a conservatorship deals with, that span of time is gone when that principal, that person can decide who will be their health care agent, where their assets are going to go, who would be the guardian of any minor children, okay? So if it's at that conservatorship stage, chances are that window has passed. And it's always unfortunate for us to hear if we get a call from a child who states their mom has dementia and they want to help them get their estate planning documents done, that window has closed. So once again, even if you're young, please do so now before you need them. Keep in mind, you can always change your estate planning documents as time goes on. Next question is if someone asked a question that if someone in their estate planning documents has specific criteria, such as they want their home to be given to this person, one of their nephews who who's in the lowest income tax bracket or has the less when they pass away, is an attorney needed? Absolutely, because it doesn't matter what the terms are of that document. You can state it goes to your neighbor or to whomever. The drafting a trust is the best way to make sure that happens. And to create a trust, you really should hire an attorney, and you want to make sure to get that home in question into that trust, and that preparing that deed. In preparing that deed, you should utilize an attorney too. So the terms really don't matter. The fact that you're creating a trust is what matters, and you should definitely get the help of an attorney in doing so, along with that deed. Great questions, everyone. So someone asked if someone has a small amounts of property and wants to distribute those to certain family members, but anticipates they will argue about what would happen. Is there a simple procedure for that? And the answer is yes. If you have the contents of your apartment and you want to make sure that a certain piece goes to a relative and your jewelry goes to someone else, if you indicate that in a will, and sign it with all the proper legal formalities, that will help keep the family peace and will prevent people from arguing about it. Because those who contest the will, as long as that will was done properly, and as long as you were you had capacity, that will provide that anyone who contests the terms of the will, they won't get anything. So that's the incentive for them to just go along with what you have taken the time to say in your will. I will add also that if you have a bank account and you want to make sure that that bank account goes to a certain relative, let's say your bank account has $5,000 in it, you can take time to sit with a personal banker or perhaps even online, if your bank allows it, and put a beneficiary on your account. And that's another way to distribute a financial asset to a certain person. All right, let's see here. So we have someone who wants to create their own estate plan, and they think that they were entitled to something through another person's estate plan, but it was never probated. First part is, if you know if it wasn't probated because that personal representative in a will or a trust in a will never got to it, you can put pressure on that person by sending a certified letter, of course. If it's a family where no one has just taken the step to get a probate done, you should definitely hire a probate attorney to get that done, especially if a house is involved. It would probably be worth the fees there, because that probate attorney will be paid out of that probate estate. But in any event, if this person creates their own estate plan and hasn't received that inherited property yet, will the heirs have to probate that estate? Yes, someone's going to, you're just kind of kicking the can down the road. Someone will one day need to probate that estate. So you can do it now, or if you or have someone in the family get that probate started by hiring a probate attorney. Because if you don't, then when you pass away, the next tier of beneficiaries will need to do so. Someone will need to eventually do it. Good question. This question is, does all property owned by a person with a spouse go to the spouse even if there are children? It really depends. So if someone with a spouse, uh, if they own property with that spouse, either as joint tenants or on a deed as community property with right of survivorship, those assets will certainly go to the spouse and they will not go to the children. A spouse can also file what's called a spousal petition and obtain what the decedent had as well. So typically, most assets will go to the spouse. However, if there was, let's say, separate property and it's a second marriage, a person can do their own estate plan and indicate that certain things will go to their own children per se. If it truly is indeed separate property and not joint property or community property. So it all depends on the written documents, and if they do provide for that. But yeah, good question. So someone has a question that if the estate is too small to cover the probate fees, what happens? Well, to go through probate, there's going to have to be at least $208,850, right? So someone who has an estate of, let's say, $500,000, I think the probate fees there are around a little under $30,000. So there's going to be enough money to cover probate fees out of an estate which is forced to go through probate. Keep in mind, if the estate is under $208,850, and cars are not included in that number, please keep that in mind. There's not going to really even be a full probate, so there shouldn't be much that needs to be covered with an attorney. Okay, if someone has under $208,850 and there's no plan and people are disputing who gets what, how would those disputes be resolved? Well, formally, someone would have to bring an action in probate court, and they could do that. So that's typically how disputes are resolved. And then people can hire lawyers, and that would seem pretty inefficient and not frugally sound with an estate that's under $208,000. So hopefully they can reach, some kind of a settlement, but probate court would be how that could be resolved. Perhaps they can all agree to some type of mediation, which would be less expensive. Because in probate court, people will typically have to hire a probate attorney. So let's say 4 people are arguing about $200,000. Is it worth it to hire an attorney to argue for your 50,000 share? But I would typically try to propose some type of mediation and have everyone sign off on that. Let's see. I don't know if I understand this question. If someone doesn't, oh, okay. Okay, so it's about if someone feels that the person who is the agent in a power of attorney is untrustworthy or doing unsavory things, not in the best interest of the principal, the person who made that power of attorney, there is something you can do. I mean, if the person is an older person, there can be a claim for elder abuse. So there are things that you can do if you truly believe that that person is, stealing money or something like that. And there are elder abuse attorneys around who do handle those types of cases. It's a fiduciary duty that the agents in these documents have to the person who named them. So they have to always act in the best interest of that person until that person passes away, frankly, okay? They can't distribute things to themselves and self-deal and do those types of things. So It's important business, definitely. Someone asked, when do people need an inventory of their property? So that inventory and appraisal is one of the steps of the probate proceeding. When something goes through probate, the judge needs to figure out what the probate fee would be, right? So they need an inventory, everything the decedent owned, the approximate value of it, and that's why an inventory is needed. Also, it lets everyone know what will ultimately be distributed. So that's the inventory that's needed. Keep in mind that while you're alive, you don't need to be accountable to anyone. You don't need to give anyone an inventory of what you have or anything like that. If you prepare a trust or do a transfer on death deed, you're not accountable to anyone. It just is there for when you pass away. And also, I will make the comment that keep in mind, let's say you created a trust because you owned a home or did a transfer on death deed, and then you ultimately sell that home before you pass away. It is what it is. It's not like, the recipients are owed something by you or anything like that. So everything is for you until you pass away. Okay, well, I guess that is the end of the questions. Thank you so much for joining us today. Christine and I welcome these questions and loved having you here with us. Great questions, and have a good rest of your day. Thank you, Claire.